Hello guys, this is Olayeni, Dear Kolola Daniels, and welcome to another episode of Dear Ko Talks Law. On today's episode, we will be talking about contract law, specifically what is consideration. But before we move into the lecture in itself, if this is your first time of coming to my channel, I want to say a very big welcome to my channel. Please make sure that you click the subscribe button as well as the notification bell, so that anytime I release a video which is going to be of interest to you, you'll be one of the first set of people to watch that particular video. Additionally, if you are on LinkedIn, then also make sure that you follow me on LinkedIn at Olayeni Dear Kolola. That is my name on LinkedIn. And so with that, we then proceed straight to our lecture for today. What exactly are we talking about? We are talking about contract law. What under contract law are we talking about? We are talking about what is consideration. If you have been following my lectures previously, you would know that I've spoken about offer, I've spoken about invitation to treat, I've spoken about acceptance to a particular extent. But one topic that I've not spoken about, which is also as important to make a contract binding, is the topic of consideration. And funny enough, that topic is what gives most contract law students a lot of headache. And this lecture is to, first of all, introduce you to what consideration is. Then subsequent lecture will then give you much more knowledge which is needed to pass contract law exam, especially on the topic of consideration. So then, what exactly is consideration? Before we go into that, we know what an offer is. When one party has said that, oh, I want to buy this thing from you, and the other party says, oh, okay, I will sell this thing to you. There is offer coming from one party to the other. When he said that I wanted to buy, and then the other says I want to sell, so we have this and we have this. That's A and B. I want to buy these things from you. Let's say I want to buy an iPhone from you, for example, and the other party is saying, okay, I want to sell an iPhone to you. Now, if the other party says, oh, I will give you the iPhone, not sell the iPhone, I will give you the iPhone, that is not a contract. Why? Because there's something missing. Although there is something going from this person, the seller of the iPhone, to this person, the buyer of the iPhone, in context. Now, there cannot be a sale if there is no contract. So when this person says I want to buy the iPhone, and when this person said I want to sell the iPhone, it's meant that this person must be giving this person something in return for that iPhone that this person is giving this person. Do you understand? In contract, not only must you have offer, which in this case is very clear, there is offer. Not only must you also have acceptance, which in this case, this other party here has accepted the offer made by this party to get the iPhone. But there must also be consideration. Now, this person here is giving this person the iPhone, right? But what is this person giving this person in return? That is the question that we would ask. Can we say that, okay, for the exchange of the iPhone, you will give me 500k? That makes sense. That is something of value, right? Okay. What about if we say that for the exchange of the iPhone, I'm going to give you my car? That also makes sense. I trade my car, you give me the iPhone. That makes sense. There is consideration. Something moving from me to you and something moving from you to me. Just like in the case of the money, something would have moved from me to you and something would have moved from you to me. Do you understand? But then, when we begin to say things like, okay, if I give you the iPhone, you are going to get married to my daughter. That's when we begin to say, is there a contract here? Or is there not a contract here? What will suffice as valuable consideration and all other things? But before I continue as to the nitty-gritty when it comes to the definition of consideration, this is just like an expose to the definition. Now I want to go deep into it, and with that, it's time for us to go to my notes. But before we go to my notes, the number one rule for you to learn as a contract law student who is for the first time reading consideration is that consideration is not needed under a contract made by deed. I told you that there are two types of contracts: formal contract and informal contract. What is formal contract? Formal contracts are contracts made under deed. And I explained to you in my class when I was teaching you types of contracts, I explained to you that when you are talking about formal contract, they are contract made under deed. And I told you what a deed is. Do you understand? That is where you have had it in writing, and then there's that red stamp there. Both parties must have signed, and there's that red stamp there. Once there's a contract under deed, you don't need consideration. I can decide to give my house A to B. I gave my house to B. Do you understand? In this case, let's say Bolanle is the person. I give my house to Bolanle, and then Bolanle is not giving me anything in return. Is the contract enforceable? No. However, if I had written it down and it was under deed, is the contract enforceable by Bolanle? Then, even in the absence of consideration, yes. In the absence of consideration, if it's not made under deed, it is not enforceable. In the absence of consideration, when it is made under deed, when you write your names, that's the parties, when you write what is being transferred, when you sign to it, and then when you put the stamp to show, that's the sign, to show that this is a contract under deed, Bolanle does not need to give me anything in return for the house that I'm giving to her. And she can go to court and enforce that I must give her the house. Yes, she can, because it's under deed. However, if Bolanle had not got me to write that under deed, and I promised to give her the land or the house in question, and then I did not give the house to her, Bolanle will sue me to court and she will lose. Why will she lose? Because she did not furnish consideration for that particular property. And that's why we then go to the second rule. Consideration must move from the promisee. What does that mean? Our first rule here is where it is a contract under deed, parties need not furnish consideration. Is not necessary. All you need to have is offer and acceptance and deed. But where there is no consideration, then you cannot enforce a contract. Where it is not under deed, you cannot enforce it without consideration. Now we now go to the second rule. Where it is a contract not made under deed, which means it's either a parole contract, oral contract, or a written contract. In the instance where it is not made under deed, it means you must furnish consideration. And while consideration can be executed or executory, but before we go into the types of consideration, the fact that it's executed or executory, before we go into what it actually means to say that consideration must move from the promisee, let us go to my notes and look at the definition as given by Lush J in the case of CURRIE and MISA. Because that definition is going to be our working definition when we are looking at consideration under the law of contract. In fact, there is no way you are going to write exam as far as you are a contract law student in any common law country, especially Nigeria, as in our context here, that you are not going to quote the case of CURRIE and MISA and then the dictum of Law J in that particular case. And that, let's go to my notes to get a proper understanding of it. Now, when we are talking about the meaning of consideration, consideration is very essential in the formation of a contract. It is a quid quo pro, meaning something for something. For example, what I said about the iPhone. When you are giving iPhone and then the other party is collecting 500k in return, that's something for something. When you are giving iPhone and the other party is collecting car in return, then that's something for something. Do you understand? Thus, conveying an idea of reciprocal interaction. In any contract, there must be mutual promises, each of the promise consisting a consideration for the other. A promise cannot be a consideration for another promise unless it is either a detriment to the party or a benefit to the defendant, as was held in the case of CURRIE and MISA. The most comprehensive and most applied definition of consideration is that of Lush J in CURRIE and MISA, like I said. Now, what did Lush J say? Lush J said that a valuable consideration in the eye of the law may consist either some rights, interest, profit, or benefit accruing to one party, or detriment, forbearance, loss, or responsibility given, suffered, or undertaken by the other party. Thus, consideration does not only consist of profit by one party, but also exists where the party abandons some legal interest in the present or limits his legal freedom of action in the future as an inducement for the promise of the first. Now, for us to understand this, just imagine that there is a case between A and B. Do you understand? Now, A sued B to court for slapping him or for doing something, and then B now decided to pay A sum of money for him to let go of the case. Can you see that? He paid A 1 million. Oh yeah, I'm sorry, I slapped you, I agree, but let us put this under settlement. Now, there has been a forbearance of a particular legal action. Do you understand? So when you're talking about consideration, let us read that second rule of Los J again. He said that consideration does not only consist of profits by one party, but also exists where the party abandons some legal interest in the present or limits his freedom of action in the future. That is his legal freedom of action in the future as an inducement for the promise. Do you see that? So that could also mean that, okay, I have a right to a particular thing, and then now because of the money that you have given to me, or because of some other detriment that you have suffered, I'm foregoing my rights. Do you understand? So, you know, these are things that we are going to look at when we are talking about consideration. We are going to break each of them down. We are going to look at whether moral obligation would be a valid consideration. We are going to look at whether past consideration would be a valid consideration. We are going to look at whether when you have an existing legal duty, would that be a valid consideration? When you have, you know, an existing contractual duty, would that as well be a valid consideration? These are things that we'll look at in my consideration class as we proceed. But now let us, you know, take a look at the last part of, you know, Los J's dictum in CURRIE v. MISA. He said it is irrelevant whether one party benefits, but enough that he accepts the consideration, and the party giving it does thereby undertake some burden or lose something which in contemplation of the law may be of value. That is one very key area that you need to understand. In contemplation of the law may be of value. And if you read the introductory part of Los J's statement in CURRIE v. MISA, it tells us that a valuable consideration in the eye of the law. So we have to look at certain context when we are talking about consideration. What will be determined as a valuable consideration in the eye of the law? Do you understand? Those are the things that we are going to look at. And then also, while continuing with my notes, it tells us that this definition was given authority to by Calgo JCA in the case of B.STOBILIRI and Company Limited versus OBASI, which is a 1997 case. Now, moving on, this means that the contract is therefore concluded as soon as the promises are exchanged. Consideration is the price at which the defendant's promises bought. Therefore, the plaintiff who is suing on a promise made by the defendant must show or prove that he himself has paid a price. That is, he gave something in return. As a general rule, once a party has given reliable consideration, it can enforce the contract. There are, however, some exceptions, like I said while I was talking earlier, where the party is under a public duty imposed by law, or where the party is bound by an existing contractual duty, or the rule in Pinel's case dealing with non-furnishing of consideration in a transaction that makes part payment of a debt a full settlement of the debt. I know that this might be a little bit confusing, but do not worry. Right now, your duty, especially in this class, is just to understand what consideration is. In my next class, I will teach you types of consideration. The fact that we have executed consideration and executory consideration. Then after that, I will teach you whether or not moral obligation would be valid consideration. And then step by step, just like that, you will be as knowledgeable as your professors on the subject matter of consideration. But with this, let us get a little insight before we end the class on what it means to say that consideration must move from the promisee. What that means is that anybody who decides to bring an action on a particular contract must have furnished consideration. Simple and short. If you know that for one reason or the other party has breached the term of the agreement, or for one reason or the other party has done something that is not supposed to do, which has resulted to some loss or whatever it is to you, and you want to sue, one of the first questions that you must ask, first of all, is there a contract? Has there been offer and acceptance? But just not that alone. You also need to ask, have you fulfilled your part of the contract? Have you furnished consideration? The moment you have furnished consideration, then you can sue. Do you understand that? So those are the rules that we discuss when we are discussing consideration, when we are discussing the definition of consideration. Those are the things that we need to look at. Do you understand? So yes, I've given you the definition of consideration, and before we end the class, you should know that there are two parties. One party must be given a right of some sort, an interest or something. The other party has to be undertaking a detriment of some sort, must be undertaking a forbearance, a responsibility. Do you understand? For debt, because we cannot give money for money. That does not make sense. Do you understand? I'm giving you 100,000 to give me 100,000. Or I'll give you 100,000 to give me 200,000. So I cannot give you rights and you to give me rights. Do you understand? So for me to give you money, for me to give you something valuable, you must give me some sort of responsibility. Carpenter, come and make chair for me. I have given you a responsibility to which I am paying you. Do you understand? So which means there is a right to be accruing to me, which is a right to a chair, while you would have a forbearance or a responsibility, in this case the chair, you making the chair and then getting money in return. Do you understand that? So when you are looking at Loss J's definition, I want you to look at each of the words that Loss J has said and understand them. Do you understand? Loss J told us that there is profit, there is benefit, there is right, there is interest from one party, and then there is detriment, there is forbearance, there is responsibility on the other party. So that is how it works. You see that? That's how it works. So don't worry, as I explain further in other classes, you will begin to understand the nitty-gritty of consideration. I hope you do understand the lectures in this class. If you have any question, so to say, you can put it in the comment section below. I would make sure to read each of your questions one after the other and give you appropriate responses. Do not forget to subscribe to my channel, and also do not forget to follow me on LinkedIn at Olayeni Dear Kolola Daniels. Thank you for being in this class. I will see you in my subsequent set of classes. Have a beautiful day.